5. So I'm going to ask our team to please start that. Okay. Again, good morning, everyone. Welcome to the Office of Tax Appeals. My name is Amanda Vasig, and this hearing is for the appeal of Morris. We have a stenographer with us today, Ms. Alonzo. She will be reporting this hearing verbatim. To ensure that we have an accurate record, I ask that each person speak one at a time, and let's avoid speaking over each other. Speak loudly and clearly. When needed, we may interject to ensure proper transcription. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. Just a reminder that the Office of Tax Appeals is not a court. We are an independent appeals body. However, we follow certain guidelines to ensure that we establish a proper record upon which a decision will be based. And we would like to conduct an orderly hearing. So each party, as we discussed in the pre-hearing conference, will have the opportunity to be heard. So please wait your turn to present your side. If you have any questions, just kind of motion at me with your hand, and when I see you, I'll ask you. I may interrupt if necessary, just to keep us on track and make sure we have a clean hearing record. Are there any questions about anything I've said before we go on the record? Okay. I'm going to check with my co-panelist. Judge Johnson, are you ready to proceed? Yes. Judge Clutter, are you ready to proceed?
This is Judge Clutter. Yes, I'm ready.
Okay. Ms. Alonzo, are you ready to proceed?
Yes, Judge.
Okay. And I do have a larger monitor here in front of me, so I will try to work my way around it, but I can see everybody. Hopefully you can see me. We are going on the record. This is the appeal of Morris, OTA case number 19115431. The date is August 13th, 2025, and the time is 10:03 a.m. This hearing is being held in Cerritos, California. I am Judge Vasig, and I will be the lead for the purpose of conducting this hearing. My co-panelists, Judge Johnson and Judge Clutter, and I are equal participants in deliberating and determining the outcome of this appeal. I'm going to ask the parties to identify themselves and who they represent, starting with the Franchise Tax Board.
Good morning. My name is James Yoon, and I'm representing the respondent Franchise Tax Board.
Good morning, Matthew Miller for the Franchise Tax Board.
Thank you. And for appellants?
Good morning, Ryan Nowicki for appellant Deirdre Morris.
Deirdre Morris.
Thank you very much. As stated in the minutes and orders, the parties have agreed that the issues to be decided in this appeal are: 1, whether the non-economic substance transaction understatement penalty, otherwise known as the NES penalty, under Revenue and Taxation Code Section 19774 is applicable, and 2, whether the interest-based penalty under Revenue and Taxation Code Section 19777 is applicable. Now, before this hearing, a hearing binder, exhibit binder, was sent to the parties. And I would like to discuss, we had a submission J from Franchise Tax Board, which was a compilation of appellants' exhibits presented at settlement. Is that correct?
Yes, that's correct.
Okay. So what we did was we allowed appellants' exhibits. Is there a need for this to be duplicated in FTB's exhibits?
I guess I'm unclear. The appellant's exhibits contain everything that was in Exhibit J. I didn't see that.
Mr. Nowicki, did you check?
So the Exhibit J includes our argument to the settlement department, whereas the exhibits that we submitted does not include our argument.
Okay.
Right.
If you wanted to keep Exhibit A but just have the letter to the Settlement Bureau, that would be fine.
Okay. So Franchise Tax Board, I just want to make sure you would like Exhibit J entered into the record?
Yes.
Okay.
Thank you.
And I'm just making sure appellants have no objection to that?
Correct.
Okay. So appellants submitted Exhibits 1 through 15, and we have not received any objections from FTB so far, and therefore Exhibits 1 through 15 are now admitted into evidence. And FTB submitted Exhibits A through J. Appellants did not object to the admissibility of these exhibits. Therefore, Exhibits A through J are now admitted into evidence. Appellants indicated during the pre-hearing conference that they would be calling Ms. Morris as a witness, and we have no objections to that. So we will go ahead and start with appellant's presentation. Now, before we begin, I'd like to place Ms. Morris under oath. You will remain under oath until the conclusion of this hearing today. Please raise your right hand. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth today?
I do.
Thank you so much. And Mr. Nowicki, you have 30 minutes for your presentation.
Great, thank you. Good morning, Your Honors.
Good morning.
As Your Honor indicated, we are here to discuss two issues. We are not here to debate the merits of the tax liability in this matter. We are not here to debate the statute of limitations on this tax matter, even though this tax matter arose in 2006. We are also not here to argue for innocent spouse relief. In my experience, this case is ripe for innocent spouse relief, but for the fact that my client inherited the estate of her deceased husband. What we are here to debate is whether the two tax shelter penalties should apply to Deirdre, and we argue that they should not apply to Deirdre. The factual background in this case is of utmost importance. In short, this tax liability arose in 2006 when Deirdre's husband, who passed away in 2021, when Bryant passed away in 2021. So in 2006, Bryant entered into a tax shelter transaction without Deirdre's knowledge. Because by that time, Deirdre and Bryant had been separated and living apart for over 16 years. The timeline of their marriage is really of utmost importance as well. And I'll give you a brief timeline so you understand the context of our position. Deirdre and Bryant met in 1971. It's important to note that when they met, Brian was 40 years old, already on his second marriage, and had 3 kids. Deirdre was 18. Deirdre was actually at a party because she was starting to date Bryant's son. Bryant became enamored with Deirdre. He courted her and convinced her to go on a 2-year sailing trip around the world with her. In those 2 years, he molded her into being submissive to him. He molded her into being non-questionable to him. And he convinced her that he had exceptional business acumen, that he would always take care of her, and that she not only should not have to worry about anything, but that she should never ask any questions. This becomes really important later on. When they returned from that 2-year sailing trip, they moved in together. In 1978, they married and had 2 children together. In 1985, they separated after many issues with Bryant and addiction. At the time, Bryant, in 1985, Bryant was living in Napa, California, and Deirdre was in San Diego. In 1990, Deirdre moved to Washington State, further separating herself from Bryant. What's important here is, even though they were separated, they remained legally married. Bryant would often tell Deirdre, and sometimes joke, that he didn't want to divorce her because paying her alimony and child support for the 2 children would be more expensive. And by staying married to her, he wouldn't have to marry any of his new girlfriends. So he was very controlling, very aggressive in what Deirdre had access to in his finances. And I'll say his finances because they really were his finances. Bryant would pay Deirdre a monthly allowance instead of giving Deirdre access to, call it the marital finances. As long as Deirdre didn't ask any questions and stayed away from asking questions, then Bryant would continue those payments. And they continued that for the remainder of Bryant's life. Deirdre had no reason to doubt Bryant's business acumen, no reason to doubt that he would stop paying. Bryant was a very successful businessman. He was a very successful real estate developer in his time. Bryant was the primary developer of the Seaport Village Shopping Center in San Diego, also a popular seaport area in Long Beach, and he was the principal developer of the Raging Waters theme park in San Dimas. He surrounded himself always by what Deirdre considered smart, intelligent business people, business advisors, lawyers, etc. So Deirdre always entrusted that she would be okay. She never doubted Bryant's ability to take care of himself, to raise, to earn income and to earn revenue. With all that said, Bryant would always tell Deirdre, don't ask. Don't ask questions. You're not in a position to ask. I pay you and that's it. With that came a relationship over a couple decades then where Deirdre had little to no knowledge of Bryant's financial affairs. Bryant would often either forge Deirdre's signature on legal documents that required a spouse's signature, or if he needed her signature, he would force her to sign essentially under duress. And again, don't ask any questions. This is all important because it leads up to 2005 and 2006. In 2005, Bryant started putting together the structure for what would become this 2006 tax shelter transaction. Bryant put together, or he created, what we and what the FTB considers sham trusts, limited partnerships, promissory notes, all in an effort to defer or evade taxes on a 2006 sale of real estate. Although Deirdre's signature appears on some of these documents, she doesn't recall signing them. And even if she did, she would have signed them under duress. Again, don't ask any questions. In 2006, Bryant sold a piece of real estate under this tax shelter transaction that we acknowledge is the bogus optional basis adjustment tax shelter. Again, Deirdre had no idea that Bryant did this. She had no idea what this structure was. She had no knowledge of his business dealings when he was doing this. Again, she's living in Washington State. They're separated. He's here in California. Sometime before 2012, the Franchise Tax Board initiates an audit of the joint tax return, again, because they're still legally married. The FTB initiates the audit. They assess a tax liability of of a little over $600,000 on the joint return. And again, Deirdre has no knowledge that any of this is going on. All of the FTB notices are being sent to Bryant, and Deirdre's in Washington State. From 2012 until Bryant passed away in 2021, Bryant kept this liability from Deirdre. She had no idea this liability was out there. Bryant and his professional advisors, both business advisors and lawyers, devised a plan to delay in hopes of running the statute of limitations on collection so the FTB would not collect. Bryant then passes away in 2021. When Bryant passed away in 2021, Deirdre became in charge of his estate and learned for the first time of this tax liability. She discussed it with his then advisors, and they advised her at the time, again, these are Bryant's advisors, stay the course, don't do anything, see if the statute will run on collections. Deirdre wanted to take, and I'm glad she took, the high road and said, no, I understand that this looks like we owe the taxes, so I'm willing to pay the taxes. But the penalties should not apply to Deirdre. And to discuss the penalties real quick, we have two penalties at issue here. There's a penalty, it's called the interest-based penalty under Section 19777 of the California Revenue and Taxation Code. This penalty was born out of the 2003 Voluntary Compliance Initiative, which we refer to as VCI 1. Essentially, under VCI 1, if the FTB contacted a taxpayer about a potentially abusive tax shelter before the taxpayer offered that information to the FTB, then the FTB can assess a penalty equal to 100% of the interest that has accrued on the taxes. Again, Deirdre had no knowledge that Bryant had reported, or that Bryant had entered into the tax shelter transaction. She had no knowledge of really what was on the tax returns, because Bryant would often file them without her knowledge or consent. And so she had no reason to come forth. So there's no reason for her, and she had no knowledge as to why she would need to comply with the Voluntary Compliance Initiative for the Section 19777 interest-based penalty. For that reason, this penalty should not apply to Deirdre. If Bryant were sitting here right next to me, we would have a very difficult time making that argument. But Deirdre is here, and Deirdre had no knowledge of any of these financial doings. The second penalty under 19774 is the non-economic substance transaction penalty. Similar to the interest-based penalty, the NEST penalty was born out of the second voluntary compliance initiative from the Franchise Tax Board in 2011. There, if the taxpayer voluntarily, or if a taxpayer was contacted by the FTB about a potentially abusive tax shelter before the taxpayer offered the information to the FTB first, then the FTB could assess a 40% penalty on that taxpayer. Again, Deirdre had no knowledge of any of these financial, say, wrongdoings that Bryant had entered into in 2006. His professional advisors also kept this information from her, so she had no reason to come forth to voluntarily comply. And so this penalty should also not apply to her. We do understand that a joint return, spouses are typically jointly and severally liable for taxes on the return. So Deirdre has from moment one offered to pay the taxes and still does offer to pay the taxes that are owed on this, but we respectfully request that these penalties not apply to Deirdre. And lastly, the subject of interest under Section 19116, the Franchise Tax Board can suspend interest, can suspend the accrual of interest on a tax liability if the FTB did not mail a notice of proposed assessment to the taxpayer within 3 years of the tax return being filed. In this case, the notice of proposed assessment was not mailed to Bryant until after 4 years after the return was filed. So interest should be suspended in this case as well. We understand that there's an exception to the interest suspension rules if the interest-based penalty under 19777 applies. But again, we respectfully request that the 19777 penalty not apply to Deirdre. And lastly, Deirdre, would you like to address the panel?
Okay. Thank you. That's embarrassing, just to hear that. Okay. I wrote a long explanation about two to three paragraphs, and then I wrote a shorter one, just doing bullet points and then I did a very short one. I don't know how much you want to hear about my background, or, I mean,
I want you to share whatever you feel is relevant to share. So in terms of timing, you have 15 minutes.
15 minutes.
So feel
All right.
free to share as much as you would
All
like.
right. I'll read the short one, and then if there's questions, I'm happy to answer. All right. 3 months before my husband died, he called me to return from Washington State to California to help him die. We had been separated for over 15 years, but that did not stop him. He expected me to help. I had met him at my high school graduation party when I was 18 and he was 42. He was immediately enamored and I was flattered. Not long after, he had a heart attack and an open heart surgery. So he gave his second wife and her 5 children that he had adopted everything, the house, the cars, the bank account, and we bought a boat and we sailed to the South Pacific. After several years, we returned at the request of his father and helped to help his brother in the restaurant business. Not long after, the city of San Diego asked him to resubmit a bid that he had made 7 years before, and it was accepted. We moved to San Diego, and he built several projects. By that time, my sons were 7 and 10. I joined a women's group and discovered that my husband was an alcoholic. We separated, and from that day forward, never lived together again. I lived in Washington State, and he lived in Northern California. My whole life, I have lived on a stipend and continue to until he died. In my longer version, I told that I didn't realize until my sons were diagnosed with severe learning disabilities that I too had dyslexia. I had just compensated. I knew when I went to high school that the headmaster said, just put your head down, don't show your work to anybody, and we'll get you through this 4 years. It was a private school, and they really wanted the tuition, and my grandfather was paying it. So I am particularly bad at numbers, but I'm not much better at letters. I've survived my life, but anyway, my husband never let me be a part of his office or any kind of goings on with money or anything like that. He just said, stand back. So he's very firm fellow. You don't really get a say. And so it, I don't know, it just caused me to be obedient. My father, my own birth father, was a tyrant, and then I married a tyrant. I don't get it. But, okay. The other things that you might want to know, Ryan said, I'm happy to, I have both my houses. I have a house and a piece of land. The house is on the market, the piece of land is on the market. I've lowered the prices. I'm trying to sell them. I'm trying to, the minute my husband died, I turned the house into an Airbnb. And during that time, I saved $100,000 from making it an Airbnb. And I've gathered monies, and I want to do right. It was the other lawyer that kept telling me, just kick the can down the road. Don't let sleeping dogs lie. Don't make a fuss. And it wasn't until I met a gal in Washington, a friend of mine, and she said, my husband's a lawyer. He could look into this. And that's when I got rid of the other lawyer, and I got Mr. Nowicki, and I'm prepared to do right. That's what I want the court to know. I can tell you other things about my life that indicate who I am as a human being, but I just want to make this right and get this chapter of my life over with, because it's been hanging over my head, and I'm 72 now, and I just want to go on with my life if I can. Yeah, that's about it, unless there's any questions you have or you want me to say more.
Thank you so much for sharing your personal story. I'm going to turn to my co-panelists to see if they have any questions for you or for Mr. Nowicki. Judge Johnson, do you have any questions?
It's Judge Johnson, no questions, thank you.
Judge Clutter, do you have any questions?
I just have one question for Mr. Nowicki. These circumstances about the lack of knowledge and lack of reason to know, what legal basis are you pointing to that the Office of Tax Appeals has the authority to waive or abate this penalty based on those reasons?
It would essentially be a reasonable cause argument that that Deirdre here relied on the business acumen of her husband. She relied on all of his professional advisors to make the tax filings to essentially take care of her financial life. And she had no reason to think that any wrongdoing was happening. We understand that the ability to get out of these penalties is severely restricted under the code. But our argument to the panel is that these penalties just should not apply to Deirdre. These penalties are intended to be punitive, to punish taxpayers who knowingly enter into these unlawful tax shelter transactions. And that may have been Bryant, but that certainly was not Deirdre.
This is Judge Clutter. Thank you. And no more questions.
Thank you.
I'd like to see if the Franchise Tax Board has any questions for Ms. Morris.
We do not.
Okay, thank you. Then at this time, we would like to move on to the Franchise Tax Board's presentation. You also have 30 minutes, and please begin when you are ready.
If possible, we would like to request a brief recess to confer.
Okay, is 15 minutes, 10 minutes adequate? 10?
Yes.
Okay, let's take a 10-minute recess. It is now 10:28. We will reconvene at 10:38, and we will go off the record at this time. Thank you. Okay, it's 10:38, and we are returning from our brief recess. Before we go back on the record, I just want to check with Franchise Tax Board. Are you ready to proceed with your presentation?
Yes, we are. Thank you.
Okay. We are now going back on the record in the appeal of Morris, and Franchise Tax Board is ready to proceed with their presentation. But before you start, I know that Judge Clutter has a question for appellants.
Yes, Mr. Nowicki, I just wanted to follow up. I should have asked this earlier, but you mentioned that the general reasonable cause and some policy reasons should apply, that, we don't apply these penalties, the interest-based and the non-economic substance penalty. I'm just wondering, are you aware of any regulations or any cases in which, under facts similar to these facts, that it was held that that lack of knowledge constitutes reasonable cause?
I'm not, mostly because in situations like this, taxpayers would ordinarily qualify for innocent spouse relief, and we don't necessarily have that here. But we continue to assert that Ms. Morris had no knowledge of the tax shelter transaction, and that she relied on Bryant to file the returns. She relied on his professional advisors to provide an accurate return. And again, she was kept out of the financial affairs of Bryant and out of asking any questions. And so, it's more of a policy argument that these penalties should just not apply to her. Because, again, these penalties are punitive, and they're intended to punish taxpayers who intentionally enter into these unlawful tax shelters, and that is not Deirdre.
This is Judge Clutter. Thank you.
Okay, Mr. Yoon, whenever you're ready.
Good morning. My name is James Yoon, and I'm representing the Franchise Tax Board. While Ms. Morris's testimony today may be sympathetic, it is not relevant to the issues to be decided by the Office of Tax Appeals today. As mentioned before, at issue is whether appellant has demonstrated that respondent has erred in applying the non-economic substance transaction understatement penalty under Section 19774 or the interest-based penalty under Section 19777. As appellant's counsel has mentioned, what is not at issue in this matter is the lack of economic substance or non-tax business purpose surrounding the sale of appellant's interest in the limited partnership to the trust. Appellant has already clearly conceded that there was no economic substance or non-tax business purpose. The lack of economic substance is further substantiated, and appellant's own submitted exhibits, as can be seen in correspondence exchanges within Exhibits 1 and 12. Section 19774 provides that where a taxpayer has a non-economic substance transaction understatement, there shall be added a mandatory penalty equal to 40% of that understatement. Appellants have conceded there was a lack of economic substance or non-tax business purpose regarding their installment sale of the limited partnership interest to the trust. As such, the non-economic substance transaction penalty should apply to the appellant. Further, Section 19774 is clear in that there is no relief available for reasonable cause or good faith regarding the NES penalty. The Code does permit the Chief Counsel of the Franchise Tax Board to compromise all or any portion of this penalty. On December 26, 2018, appellants did request relief from the NES penalty from the Chief Counsel. This request was denied on July 12, 2019. Additionally, Section 19774D3 makes clear that this determination by the Chief Counsel is not reviewable in any administrative or judicial proceeding. As such, the NES penalty was properly imposed because appellant's transaction lacked economic substance as defined under Section 19774. There is no relief or abatement available to appellant. With regard to the interest-based penalty, Section 19777 imposes this penalty where a taxpayer has a deficiency attributable to an abusive tax avoidance transaction and has been contacted by the Franchise Tax Board regarding this abusive tax avoidance transaction. Pursuant to Section 19777, an abusive tax avoidance transaction includes a transaction to which a NEST penalty under Section 19774 applies. This penalty is added to the tax in an amount of 100% of the interest payable under Section 19101 for the period beginning on the last date prescribed by the law for the payment of that tax and ends on the date the notice of proposed assessment is mailed. As discussed before, respondent properly imposed a NEST penalty. Where there is no dispute, the trust and installment sale transaction at issue lacked economic substance. Respondent notified appellant of its determination that the transaction lacked a non-tax business purpose. Accordingly, respondent's imposition of the interest-based penalty equal to 100% of the interest payable on the understatement was proper. Additionally, Section 19116, as discussed, does not apply to any penalties, addition to tax, or additional amounts relating to any abusive tax avoidance transaction as defined in Section 19777. This is specifically covered in 19116 D8 of the Revenue and Taxation Code. In conclusion, the Revenue and Taxation Code is clear where there is an understatement attributable to a transaction that lacks economic substance or a non-tax business purpose. The imposition of the NEST and interest-based penalty is appropriate. There is no disagreement that the installment sale of appellant's limited partnership interest lacked economic substance or a non-tax business purpose. Therefore, both penalties are applicable and were properly imposed. Respondent respectfully requests the Office of Tax Appeal sustain Franchise Tax Board's action. Thank you, and at this time, I'd be happy to answer any questions the panel may have.
Thank you, Mr. Yoon. I do not have any questions. I'll check with my co-panelists. Judge Johnson, do you have any questions?
As Judge Johnson, no questions. Thank you.
Thank you. And Judge Clutter, any questions?
This is Judge Clutter. No questions. Thank you.
Okay. No, Mr. Nowicki, as we discussed in the pre-hearing conference, appellants have the last word here, so I'd like to offer you 5 to 10 minutes for a rebuttal if you would like to take that time.
Sure, thank you.
Okay. You may begin when you're ready.
Thank you. I will be brief. I think we have expressed to the panel sufficiently enough that Deirdre had no knowledge of the 2006 tax shelter transaction. She was kept away from Bryant's finances and his financial affairs. She didn't even know about the audit or about the tax assessment until Bryant had passed away in 2021. If Bryant had applied to the chief counsel for relief of one of the penalties prior to 2021, and FTB asserts that the chief counsel of the FTB denied that relief in 2019, then Deirdre was not part of that. Again, Deirdre did not even know that this liability existed until 2021 when Bryant passed away. So that relief, that request of the chief counsel of FTB did not come from Deirdre, and Deirdre had no knowledge of it. Again, this is Bryant's sole and exclusive conducting of all of the financial affairs of their separated marriage. As far as the interest goes, we understand that there is an exception under 19116 for suspension of interest if one of the tax shelter penalties applies. Again, our position is that these tax shelter penalties should not apply to Deirdre. She was not the one who entered into these. She had no knowledge of them. And because the tax shelter penalties should not apply, then interest should also be suspended as well. That is all we have.
Thank you very much. Judge Johnson, do you have any questions at this time?
This is Judge Johnson, no questions, so thank you.
And Judge Clutter, do you have any questions?
This is Judge Clutter. No questions. Thank you.
Okay. Thank you so much. This case is now submitted on August 13th, 2025. The record is now closed. I'd like to thank the parties for participating today and thank Ms. Alonso and OTA staff for ensuring that everything proceeds smoothly and we have a clean record here. The judges will meet to deliberate on this matter and we will issue an opinion within 100 days from today. Today's hearing in the appeal of Morris is now concluded. Thank you, everyone.
Thank you.